John Fox. I'm like, who knows everything there is to know about marijuana? And John was like, oh, and I mean that in the best of ways. Although I must say only 3 people got the incense joke. And I know some people out there, know about puff, puff, pass, pass. But anyway, John Fox said, I saw this guy in trial. His name is Daniel. Give him a call, see if he'll come. So Daniel's going to be doing this probably yearly now. So I give you the dopest lawyer in town.
Thank you. As Stephanie said, we're going to talk about marijuana. I wasn't really sure what I wanted to talk to you guys about. I didn't know what everybody's level of experience with marijuana is.
Oh, they can't hear you.
Okay, let me.
What were you saying about smoking the water?
So I moved down here from Colorado before I became a lawyer in San Antonio. I used to work in the marijuana industry. I fully believe in the legalization of marijuana. And a lot of winning these cases is going to have to do with that. First, I'm going to give you. Okay. First, I'm going to briefly talk about the law. You're pretty much screwed on that. Pelham v. State says usable quantity is the amount required to roll a marijuana cigarette or use it in a pipe. I'll tell you the industry standard is a bowl pack is about 0.3 grams, but a creative pothead will smoke even a minuscule amount. So usable quantity, you're pretty much screwed on that. Possession of marijuana, defined as care, custody, or control of the substance. You're not going to win on that most times because your guy had the weed. You got to remember cars. Cars are an exception to your search warrant requirement. If there is reasonable suspicion, they're going to get in the vehicle, they're going to search the vehicle, they're going to find pot. Rodriguez v. United States just came out in April, stands for the proposition they cannot delay a traffic stop past the time required for the ministerial duties to complete the actual traffic stop. In that case, they finished writing him a ticket, they kept him on the side of the road for 7 minutes, brought a dog to the scene. It was determined that was an unfair detention. Everything went away. Riley v. California, you may not see it so much in misdemeanor court, you will see it in felony court. Anything involving a cell phone, they need a search warrant to get in the cell phone. It's a bright line rule. Fourth Amendment's not completely dead. Okay, now let's talk about, you get past that and we get to trial. How do you beat one of these cases in Bexar County? What you can find is most people here think marijuana should be legal. You need to pull a diagram, set them up for nullification. You're going to draw a lot of objections from prosecutors, but you do it properly. You're allowed to pull your jurors on what they know. Ask them, does anyone know that marijuana is legal in Colorado? You're going to get an objection, but there's nothing wrong with that question. Ask them, does everyone know that in Colorado there's 16,000 employed people in the marijuana industry? That they did $700 million in retail sales in their first year. You can find out a lot of people don't know this, but you're also going to find a lot of people don't think marijuana should be illegal. So you set them up to nullify. You also need to talk to them about jury verdicts being sacrosanct. Tell them, explain to them, sell it to them. They're going to go back there, all 6 of them. You're going to get in the back, they're going to take your cell phones away. You're not going to be able to talk to the outside world while you deliberate on this matter. This is important, but what you do is sacrosanct. You can do whatever you want. Let them know that. You're going to get an objection, you're going to get a jury, or you're going to get a panel that wants to nullify it. Don't think this should be illegal. Judges are going to tell you you're not going to nullify. They might even try to sustain the objection, but you just tell them, Judge, what I said is perfectly correct. You can do whatever you want. Jury verdict is sacrosanct. Okay? Now, you're going to actually proceed to trial. You've got your jury set up to nullify it. You've got an officer, he's going to get on the stand. Again, the case law is going to screw you. Here in Texas, it's sufficient for him to say that he identified it through his training and experience as marijuana. Real life, that's nonsense. We have synthetic marijuana now that's actually designed to look like marijuana. I think the old case law is probably bad in a modern environment. I would cross the officers, and I do cross the officers on when the last time they were around marijuana was. I had an officer tell me last time he was around pot was 10 days ago with his friends. True story. That's a true story. They can't identify pot. A lot of officers don't know what it is. They don't actually know the smell of marijuana. They'll tell you that the last time they were around pot was at the police academy. They do a controlled burn, they're trained on the smell, but that's the only time they've ever been around it. So they don't actually know the smell. Jurors eat it up. Okay? The other rule I want to talk to you about in trial is make it about anything other than whether or not your guy had the weed. If he had the weed, you're dead in the water. If you talk about that, you will get people convicted. People get convicted of these, even though it's a Class B misdemeanor. These drug convictions, they do carry heavy penalties. They can impact ability to get financial aid for college. You will lose your driver's license for a Class B misdemeanor. You will have to take the DOEP course to get your driver's license back. So these do come with actual penalties, so I don't want a bunch of people running around getting drug convictions. Let you in on a secret. Here in Bexar County, there's not a misdemeanor pot case they won't JSAT or they won't give you a one-day deferred on. You can set your clients up and go get them a one-day deferred. I'm going to tell you don't do that. Take it to trial, set it for trial. They're never actually bringing the weed. Technically, they don't have to under Texas law. Again, an appellate court can screw your client, it will. So they're not going to bring the weed in. Argue it to the jury. I call it the unicorn defense. Argue, they could charge him with possession of a unicorn, but if he doesn't come in here with the unicorn, the presumption of innocence is you will find this man not guilty. Okay? Be prepared to argue that. Think outside the box. Don't get boxed in by the law because you will lose if you let the law box you in on these. You also need to know numbers. 0 to 2 ounces. What does that mean? They're weighing in grams. 56 grams is 2 ounces. 112 grams is 4. You need to know that because you will see that where they're mischarging some of these and you can immediately start bargaining. You'll also see disparities between field test results on the weighing, where they're weighing them on a little digital scale, and the actual lab results. That is fertile ground for cross-examination of the officer as well. My officer who had been around pot 10 days earlier with his friends, the bag weighed 3 grams more when he weighed it on the hood of his car versus when the lab weighed it. Juries eat that stuff up as well. Okay? Numbers are important. Circumstances are important. Now, going back to our voir dire, things you want to talk about to get your jury in the mindset. You've got a minority, which a lot of these cases you are going to have minorities. There's huge racial disparity. Voir dire on it. You're 8 times more likely to get arrested for marijuana if you're African American than if you're white. You're 4 times more likely if you're Hispanic than if you're white. These numbers are in the paper. I will confess the paper, the statistics are a little bit old, but the numbers have not changed very much. All the ratios are still correct as far as racial disparity. Talk about anything other than whether or not he had the weed. Get your juries upset. Talk about bad cops. If you think there's anything about the stop, talk about bad cops. And voir dire, talk about these cops shooting people. Anything you want to. Get them thinking about anything other than whether or not your guy just simply possessed marijuana. Other than that, I don't have a lot to tell you. I mean, it's not a great secret. Marijuana is, we're getting there. I'll tell you, you're going to see DWIs in misdemeanor court now where they're charging marijuana. A little bit on that. I'll tell you, there's no scientific basis connecting any blood level intoxication of THC to a level of impairment. The science is completely different than what we do with alcohol. There's absolutely no basis to it. Set those for trial. Those charges are bullshit. Okay? You're also going to start seeing hash charges. Hashish concentrates. You'll hear it called wax, butter, earwax, BHO for butane hash oil. That stuff is a controlled substance under Texas law. It is filtering down from Colorado in a lot higher quantities, and you'll see it mischarged as a misdemeanor. If you see something that is described as anything other than a leafy green substance, plead that out that day. Take that deferred, burn those facts before the state realizes it's a felony. okay? You're gonna see a lot more of that. That's about it. Good luck, and if you need any help, my email is danielmehlerlaw@gmail.com. My office number is 210-816-0529. Don't hesitate to email me or call me. I'd be more than happy to sit with you, answer any questions you've got, try to help you in any way that I can. Thank you. Anyone have any questions?
How many that you set for trial do you actually try versus dismissals?
You're chasing a unicorn. They're not going to try a lot of them. I'd say 95% of the cases are getting dismissed after a second not ready. They don't want to lose these cases. They're a little bit embarrassed by it. And they'll go away. Just set them on the trial docket. Know that you can always take that deal. If you want to mitigate the risk, have your client do some community service, take that DOEP, and come prepared on the day of trial to take a one-day deferred. You can always do that. But in case they're getting dismissed on not ready constantly. Anything else? All right, thanks, guys.